I'm Paul Locke, and I'm here today to talk to you about laboratory animal law. That's the topic that describes how animal use is governed in research facilities, education, and testing. I'm an attorney, and I'm admitted to practice law before the bars of the District of Columbia, the State of New York, and the United States Supreme Court. I'm not in active practice now, but when I was, most of my practice involved environmental law, although I actually started my career as a Wall Street lawyer. I came to animal law because of a particular problem that I saw evolving in environmental law, and that's the problem of toxicity testing of chemicals. We obviously use a lot of chemicals and they end up in the environment, and we need some way to determine whether those chemicals are harming humans and non-humans. Normally, we try to figure that out by using toxicity testing that is heavily animal dependent. Those tests, though, have certain limitations, so I began to look at other ways of doing that testing, and I discovered this field of alternatives to animal testing. That got me into animal law, and I've been working on animal law issues for about 20 years. I'm also a scientist. I hold a master's in public health from Yale University and a doctorate in public health from Johns Hopkins University, where I'm now on the faculty. I wanted to tell you, too, that as a faculty member at Hopkins, I work mostly on science policy issues. My research and practice don't involve animal experimentation, but what I do is I try to look at what happens when science escapes from journals and from labs and gets in the hands of policymakers. I try to use science proactively to improve laws, policies, and regulations so that laws, policies, and regulations can create a better world for both human and non-human animals. And one of the key ways I do that is to work on developing and improving the field of laboratory animal law. I'm going to talk now about some of the key terms and phrases that you need to know to really understand this field. I've divided them up into three groups. The first group involves what I'm going to call animal-centric terms. The second group involves organization-centric terms. And finally, the third group are science-centric terms. So let's start with the animal-centric terms. And the first one, which is pretty obvious, is the definition of animal. Now, if you're a lawyer, or you work with lawyers, or you're familiar with laws, you know that definitions are very important because they determine what's covered and what's not covered by any statute. So defining animals is a good place to start. Now, under the Animal Welfare Act, the term animal has a very convoluted definition. It means any live or dead dog, cat, monkey, non-human primate, guinea pig, hamster, rabbit, or such other warm-blooded animal that's being used or intended for use in research, testing, experimentation, or exhibition. Now, the definition actually is longer than that, and one of the things the definition has in it are exclusions. So most farm animals are excluded from the definition, but another exclusion from the definition, which is quite noteworthy, is that any rats, mice, or birds that are bred for research purposes are actually excluded from the definition of animals. I think that's quite striking, given that between 85 and 95% of all animals used in research are rats, mice, and birds bred for research purposes. Under the Health Research Extension Act, the definition of animals is found in one of the public health policies. And what it says is that animals are any live, vertebrate animal used or intended for use in research, research training, experimentation, or biological testing or related purposes. So what you can see about these definitions is that while they overlap, they are quite different. For example, vertebrates are covered by the Health Research Extension Act. So an animal like a zebrafish would be covered by that law. However, because a zebrafish is not a warm-blooded animal, it's not covered by the Animal Welfare Act. By the same token, dead animal tissues used in research are covered by the Animal Welfare Act, but they're not covered by the Health Research Extension Act. And again, just to emphasize, 85 to 95% of animals used in research facilities are rats, mice, and birds bred for research purposes, yet they are not covered by the Animal Welfare Act. So it's probably no surprise to you that given this hot mess of definitions, we don't really even have a good count of the number of animals we use in research in the United States. We just have guesstimates. All right, so that's the first term I wanted to go over. The second animal-centric term is welfare, pain, stress, and distress. So why are these important? Well, the first thing I should point out about them is that these are not terms that are defined in the statutes. There is a term definition for painful procedure, which is contained in the Animal Welfare Act regulations, but the other terms are not defined. And that's noteworthy because a lot of what these laws and policies are supposed to do is eliminate or minimize pain, distress, and stress to animals. I should point out that a painful procedure is considered to be any procedure that would create more than momentary pain in a human. So that at least is some touchstone for what pain is supposed to be in animals. The definition of pain, stress, and distress is, however, found in something called the Guide for the Care and Use of Laboratory Animals. And that is a key document that really is probably the most important document in this field that is not a law. The guide was written by a committee of experts assembled by the U.S. National Academy of Sciences, and I was on this committee. I was on the committee that wrote this version of the guide. The guide is updated frequently, usually once every decade or so. So by the time you're listening to this, you may be looking at another version of the guide. The last animal-centric term that I want to go over is welfarism and abolitionism. Now, these are ethical or philosophical terms that describe the way people consider animals and how they should be treated. Generally, under a welfarist system, animals are given humane care and treatment, their pain is minimized, and welfarists tend to work within the current system to do the best they can to make the lives of animals better. Not so with abolitionism. Abolitionists feel that animals as sentient creatures deserve a fundamental set of rights, and they would eliminate, some sooner rather than later, the use of animals in laboratories and in many other systems. I'm going to talk now about organization-centric terms, and I want to start with an acronym, APHIS, A-P-H-I-S. APHIS stands for the Animal Plant and Health Inspection Service, and it's a group within the USDA, the United States Department of Agriculture, that's in charge of implementing the Animal Welfare Act. And remember, the USDA has a mission of both encouraging animal use as well as regulating animal use. So it's got kind of a dual and mixed mission. The next term that I want to point out to you is another acronym, OLAW, OLAW, and that stands for the Office of Laboratory Animal Welfare. That is an organization that exists within the National Institutes of Health, which is, of course, part of the Department of Health and Human Services, and its job is to implement the Health Research Extension Act. The National Institutes of Health has a dual mission here. It is one of the major funders of animal-based research in the United States, and at the same time, because OLAW is part of it, it's in charge of regulating the use of animals in research. The next term I want to talk to you about is IACUC and IO. And IACUC is an acronym, and it stands for Institutional Animal Care and Use Committee. As we'll learn, IACUCs are at the center of the self-regulatory system that comprises laboratory animal law. Now, if you look at the regulations and the policies, you'll see IACUCs are very complicated. They do a lot of things, but I think we can boil it down to three major functions. The first function is that IACUCs have to semi-annually inspect all animal care facilities and laboratories that use animals. The second function is that they have to write reports about those inspections and file those reports at the institution. And those reports have to discuss if there were any deficiencies in their inspections. The third thing that IACUCs do is that they have to review and approve all protocols that involve animal use. So again, IACUCs are right in the center of our regulatory process here. Now, what is an IO? An IO is an institutional official, and that is the official at the facility that has both the authority and resources to make sure that IACUCs can do their jobs. So let's move on to our last group of key terms and phrases, those that are scientific-centric. The first term I want to introduce to you is the term scientific research. And scientific research is the collection, evaluation, interpretation of data in a transparent and systematic way. Scientific research almost always involves something called the scientific method. And the scientific method begins when a researcher constructs a hypothesis, which is her theory about how this particular piece of the world works. That hypothesis is then tested with data, and the researcher will then look at how the data influences the hypothesis. Does it support it? Does it refute it? Does it alter it? And will go on to collect more data and alter the hypothesis accordingly. So as hypotheses become fine-tuned, they're collated and collected, and they move from hypotheses to scientific theories. Now, I know this sounds very, very theoretical, so let me give you a concrete example. And let's think about how scientists showed that smoking cigarettes caused lung cancer. After World War II, there was a rise in cigarette smoking, and this led some people to make anecdotal observations that smokers seem to be at greater risk for getting lung cancer than non-smokers. So scientists collected data in humans. They looked at humans who smoked, and they looked at humans who didn't smoke, and they compared those populations to see if there were differences in the rates of lung cancer, and sure enough, there were. So in that case, you have a hypothesis that's borne out by the data. That led to other hypotheses that scientists wanted to explore. So for example, was there a relationship between the number of cigarettes smoked and the risk of lung cancer, which is known in public health science as a dose-response relationship? So again, scientists studied humans, and they asked humans how many cigarettes they smoked, and they evaluated whether those who smoked more were at higher risk for lung cancer than those who smoked less. And indeed, they found out that was true. That then led to another series of hypotheses looking at how cigarette smoke actually causes cancer. And for that, animal research was needed. Animals were exposed to cigarette smoke, and then their tissues were studied so we could understand the biological basis for how smoking and lung cancer were related. Now, that science unfolded over the course of about half a century, but I think one of the things that's important to emphasize is that very often scientific research is like shining a weak flashlight into a dark cave. You can see the outlines of things maybe, but the exact details require an enormous amount of work because of the complexity of science, especially science related to human health. Scientists have to work very hard to study how diseases occur, how to prevent diseases, and how to develop cures. And they do this to make the world a better place for both humans and non-human animals. The last term I want to introduce to you is a term called the 3 R's. These are 3 concepts that were introduced to the world in a book called The Principles of Humane Experimental Technique, written by 2 British scientists, Russell and Birch, in 1959. The 3 R's that Russell and Birch introduced are replacement, reduction, and refinement. Let me talk about each one of those terms. Replacement means replacing animals in experiments with non-animal methods. So for example, instead of using a rodent model, simulating something on a computer. That's also known as absolute replacement. Another type of replacement, which is a relative replacement, is replacing higher order animals with lower order animals. So for example, replacing non-human primates with rodents, or replacing rodents with things like planaria, which are worms, or Drosophila, which are fruit flies. That's relative replacement. The second term, reduction, means that you use fewer animals in your research to get the same quality of scientific result. And the third term, refinement, means that if you do have to use animals in an experiment, you make sure that those animals are free as possible from pain, stress, and distress. The reason for that is not only humane, but is also because that is one of the things that allows you to do quality science. If the animals are under stress, then the results you get are not going to be the type of results that we can really rely on. So that's one of the reasons why the guide is so important. I want to talk now about the two federal statutes that underlie this area of law. And I'm going to do that by first introducing their history, because if you don't know where you've been, you don't know where you're going to go. So let's start with the Animal Welfare Act. Now, the Animal Welfare Act was first passed in the 1960s, but truth be told, in the United States, there was a long-standing concern about animals used in laboratories. It actually dates back to the 19th century when states tried to legislate in this area, although none were successful. Things really got rolling in the 1960s in Congress, and in fact, during that decade, Congress received more letters about animal welfare and animal care issues than they did about the Vietnam War and about civil rights combined. Think about that. It wasn't, though, until about 1965 that Congress acted. And I think one of the major reasons they acted was because two very, very popular magazines at the time, Sports Illustrated and Life, covered this issue. Sometime around Thanksgiving in 1965, Sports Illustrated came out with an article that described the theft of a Dalmatian dog who was a companion animal. That dog, whose name was Pepper, was taken from their owner and sold into a research facility. We don't know for sure what happened to Pepper, but there's good evidence that Pepper was taken to a New York City hospital, experimented on, and euthanized. That led to a massive public outcry, as you would expect. Another article that was published around that time was in Life magazine, and the title of the article was Concentration Camp for Dogs. The article contained graphic pictures showing the lives of dogs at dealers before they were sold into research. These two articles really spurred on public sentiment, and as a result, Congress ended up passing legislation which was signed into law by President Lyndon Johnson in 1966. The title of this law was the Laboratory Animal Welfare Act, and it had two major purposes. The first purpose, not surprisingly, was to keep companion animals from being stolen and out of labs. The second purpose was to give the United States Department of Agriculture some authority to regulate so that animals had better husbandry standards. And indeed, the law did both of those things. The Laboratory Animal Welfare Act was amended many times. In fact, it was amended in 1970 and 1976, and its name was changed to the Animal Welfare Act during that time. But I'm not going to discuss those amendments in any detail. Instead, I want to focus on the 1985 amendments because those amendments were the most impactful ones for laboratory animal law. So, what changed in 1985? In 1985, there were at least 6 things that were added to the Animal Welfare Act that had major changes. The first thing that was added is a requirement that all research facilities have IACUCs. We've discussed IACUCs already, so you know what they do. But this is where they got into the law. The second change was that researchers and facilities had to minimize or eliminate all pain and distress to animals unless the research protocol called for studying pain or distress and it couldn't be eliminated, in which case the IACUC had to approve that. The third change was that higher order animals, non-human primates, dogs, cats, some other animals, had to be given enrichments. The fourth change was that training was required for anyone working with animals, including principal investigators. Fifth, there was a requirement placed on researchers that they review the literature to see if there were non-animal alternatives that were available before they used any procedures that created pain or stress in laboratory animals. And lastly, there was a library created that was a resource for researchers to go to make sure that their research wasn't duplicative, and also to learn whether there were alternatives that were available for the procedures they were using. Another thing that this law did was it required the USDA to inspect all of these facilities at least once a year. Now, after 1985, there were 5 more amendments to the AWA. I'm not going to go over those. I do, however, want to point out one very important amendment in 2002. That was the year that language was added to the definition of animals in the AWA that removed rats, mice, and birds bred for research purposes. Let's talk now about the history of the Health Research Extension Act. And this is much simpler than the Animal Welfare Act's history. The Health Research Extension Act was passed in 1985, and incidentally, it was passed together with the 1985 AWA amendments. Both of these were very controversial, and in fact were passed over President Reagan's veto. The actual language in this law that covers animal welfare is quite short. It's only about a page and a half, and its provisions largely parallel the Animal Welfare Act. Now that we've had a chance to discuss the history of the Animal Welfare Act and the Health Research Extension Act, let's do a little bit deeper dive into the laws and regulations. I want to start by pointing out that the Animal Welfare Act is really in many ways a typical administrative law. That is, Congress passes a law that contains general provisions that it wants implemented for the public good, and then it delegates authority to an agency to write regulations to implement those general principles. And that's essentially what happened here. So what does this whole system look like from the perspective of the laws? So the first thing is that all facilities that do laboratory animal research have to register with the USDA. That means they have to get a copy of the regulations and law from the USDA, and they have to tell the USDA that they are going to comply with those laws and regulations. They have to establish IACUCs, which are the center of the self-regulatory universe. They have to promise to keep records at the facility. They have to inspect and enforce, and they have to report out to USDA, but only serious violations that would otherwise not be fixed in-house. And the USDA can take then an enforcement action. USDA can also issue a cease and desist order, which means that they can order a facility to stop behavior that is harming animals and is violating the AWA laws and regulations. When we think about enforcement under the Animal Welfare Act, I want you to remember, though, that the gist here is that most things should be handled in-house. The IACUCs and the principal investigators should be able to resolve any problems that they see. That's how the statute is mainly written. Only the most serious violations are reported out to the USDA. Let's now talk about the Health Research Extension Act and what it says. For the most part, the Health Research Extension Act parallels the AWA, but there are some structural differences, and I want to talk to you about those now. One of the first structural differences has to do with coverage. The Animal Welfare Act was passed by Congress using its Commerce Clause authority because, simply put, laboratory animal research is interstate commerce. In contrast, the Health Research Extension Act is triggered by funding. That is, if you get money from a public health agency, you are covered by the Health Research Extension Act. In addition, the Health Research Extension Act does not have regulations. It's implemented through a series of guidance documents. And in fact, if you look at the first line of the law, that's exactly what it says. And there are two main sets of policies or guidance documents that underlie this law. The first one has a rather long title: the U.S. Government Principles for the Utilization and Care of Vertebrate Animals Used in Testing, Research, and Training. And it has 9 what I'd call aspirational goals. I would divide those into 2 groups. The first group relate to how animals are treated. So that covers transportation, it covers housing, it covers vet care. And the second group relates to the research itself. The principal investigator and or the facility has to make sure the research is not duplicative and make sure the research is a benefit to society. The other set of policies is called the Public Health Service Policy on Humane Care and Use of Laboratory Animals. And it reads much more like a regulation. For example, it has assurances in it, so the facilities have to point out that they can actually comply with the HREA. It talks about the establishment of IACUCs, and it talks about inspections. So that is really how the HREA is implemented through policies. All right, so given this little bit of a deeper dive, given the history, let's talk about the system. When you knit this all together, how do things operate? To kickstart that discussion, I want to go back and look at a quote from a gentleman named William Proxmire. Mr. Proxmire was a senator, and he was very influential in the laboratory animal field. In fact, he introduced one of the first bills in this area. And this quote is a quote that comes from him during the time that bill was being introduced. And I want to read it to you because we're going to take some time to break it down. Clearly, there are 2 sides to the animal experimentation questions. On the one hand, such experiments have made possible great scientific and medical achievements. On the other hand, some thoughtless or careless experimenters have inflicted unnecessary pain and suffering on laboratory animals. What is needed is an approach to this question which preserves the necessary and useful aspects of animal experiments while preventing the abuses. So with this quote in mind, let's go over some of the characteristics of this system. Well, the first major thing that we need to focus on is the fact that the system is a self-regulatory system. Basically, the institutions are in charge of regulating themselves. There's a premium put on fixing things in-house. So remember how this works. IACUCs do inspections. If they identify deficiencies, they work with the researchers to fix those deficiencies. Again, all that happens within the institution. It's only if there's a serious deficiency, which is uncorrected, that gets reported out to the regulatory agency. Now, in my experience, that's really unusual for administrative law. When I practiced environmental law, the EPA as a regulator was very, very aggressive in policing the regulatory community. Not so here. The regulatory community polices itself. That brings me to my second point about this system. How would you think about and describe the regulators themselves? I would describe them as light touch regulators. And again, that's because while they are required to inspect facilities, while they are required to get certain assurances from the regulated community, basically what they're focusing on are the really, really bad situations, the bad actors. Yes, they can go into facilities and they can look at records, but for the most part, again, things are done in-house. Another unique thing about this system, and we've gone through this, but I want to emphasize it, is that only some of the animals are covered and only some of the time. So remember our definitions. Not all vertebrate animals are covered by the Animal Welfare Act. Dead animals and their tissues are not covered by the Health Research Extension Act. Rats, mice, and birds, which make up between 85 and 95% of all research animals, are not covered by the Animal Welfare Act. So you have a system that is very, very uneven because of these convoluted definitions. The other thing to look at is the coverage of the institutions themselves. This set of laws doesn't cover all institutions the same ways. In fact, some institutions are covered by both laws, while some institutions are covered by neither law. Take an academic institution, for example, that gets money from public health agencies. That would be covered by both the Animal Welfare Act and the Health Research Extension Act. In contrast, think about a contract lab that does toxicity testing and uses only rats, mice, and birds. That wouldn't be covered by either law. So this kind of leaves you with this feeling that there's a certain amount of arbitrariness and counterintuitiveness in this system. And it raises the question, should the public have confidence in a regulatory system that is so filled with gaps? Now, another thing about the system is while it does provide some protection for animals, the protection and the coverage is very limited. As we've discussed, this is a 1R law. It's really a law that focuses on minimizing pain and distress, that 1R being, of course, the refinement R. And it also provides some enrichment to some animals. Finally, this is a system that leaves an evaluation of scientific merit to others. If there is a scientific merit review, that's either going to be done by the principal investigators or the research facility, or it's going to be done when the principal investigator and research facility have first submitted their research projects for funding. The way the laws are written, the researchers hold the keys to the laboratory door. There are provisions in the Animal Welfare Act that basically say that IACUCs cannot regulate research. So this is kind of confusing, and it's a fuzzy line because IACUCs can talk about animal welfare, they can talk about animal numbers. So let's go to the guide, because the guide has an interesting quote on this, and again, I want to read it to you so you can get more of a feeling as to what's going on here. While the responsibility for scientific merit review normally lies outside the IACUC, the committee members should evaluate scientific elements of the protocol as they relate to the welfare and use of the animals. For example, hypothesis testing, sample size, group numbers, and adequacy of controls can relate directly to the prevention of unnecessary animal use or duplication of experiments. When you read this and you think about what IACUCs can and can't do, it raises questions about how aggressive they are. And since we don't know on a facility-by-facility basis how IACUCs operate, because that information is not available to the public, it again raises the issue of whether this system is really functioning in a way that engenders high public confidence. So, just to summarize, in my view, the system of laboratory animal law regulation we have now was set up to solve a mid-20th century problem. I think it does that. But I think we need to ask ourselves the question about that system. Is it something that's going to help us in the 21st century where we face different challenges? And that's the question I'd like to turn to now. To open this discussion about the future, I want to point out that the world of laboratory animal welfare and laboratory animal law is a very polarized system. And right now, we have two forces in the 21st century that create a push and pull tension in this field. I call this the cures versus creatures dilemma. Let me break it down for you in a little bit greater detail. On one hand, there's a strong societal force represented by scientists and activists who really see the need to use animals and animal models to understand biology, to cure diseases, and to prevent future harms. On the other side, you have a strong force in animal activists who recognize that animals are sentient creatures, that animals have cognition, that we study animals because they are like humans in many ways, and they want animals to have a fundamental set of rights that are respected in all legal regimes. My experience has shown me that there's very little discussion between these two different groups. So again, you have these countervailing forces that are creating tension within the laboratory animal law system. So how do we resolve this? How can we move forward given this polarization? Well, I think that the first thing we need to do is recognize that given the current state of science, and I say this as someone who's read quite a few scholarly articles on science and also published a few articles in the scientific journals about the state of the science, my take is that we cannot immediately abandon our use of animals and animal models. Animals are still needed if we're going to make any progress in curing diseases, in identifying the underlying biology that causes diseases, and in developing prevention methods. That is true not only for diseases among humans, but also for diseases and conditions that non-human animals have. Remember that science is often like shining a weak flashlight in a dark cave. Right now, while animal models may have limitations, in fact, animal models do have limitations, they are one of the tools we use to improve the state of the world. However, there's another side to this story, and that side is that there's a rapidly developing field of science that does not use sentient animals for research. This includes developing technologies such as organ on a chip, where you can actually simulate a human or animal organ on a little piece of plastic. It includes creating organoids by extracting and growing cells from different organs and putting them together so you can study something that is very similar to a living organ. It includes also the ability to use the computer to simulate what's happening in the body. All of these technologies show great promise for the future. So I'd like to move away from this tension, this cures versus creatures discussion of what faces us, and ask another question. And that question is, can we wean our science off non-human animal methods? And if so, how? To me, this is a win-win question. Can we develop better science while at the same time using fewer, maybe even virtually no animals in our research? And by the way, I believe the answer to this question is yes, and I'd like to talk about how we can get there. To begin to answer this question, I'd like again for us to gaze over our shoulders and think a little bit about history. And I want to take you back to the summer of 1969 in the United States. For those of you that have studied history, you know that in that summer there were two great social and cultural events. Now, just for a minute, without going to the internet, try to think about what they were. For those of you that guessed Woodstock and the moon landing, you got 100% on this quiz. Congratulations. I'm going to spend a little time talking about one of those events. Unfortunately, it's not Woodstock. I'm going to talk about the moon landing. For those of you that want a Woodstock story, well, maybe later. So let's talk about the moon landing. You probably know that the moon landing required a lot of scientific knowledge, both applied and theoretical. And one of the key tools that was used to develop that knowledge and put it into practice is this. This is called a slide rule. And believe it or not, it's a pretty powerful little engineering tool, a great way to do calculations. And this is the same model slide rule that astronaut Buzz Aldrin used as he was descending the capsule to the moon to do some last-minute calculations. So as a result of this slide rule, we had a massive scientific, cultural, and social success. So why am I bringing up a 1969 slide rule right now? The reason is I think it helps us frame the challenge before us. Now that you've gazed back 50 or 60 years into the past, let's look 50 or 60 years into the future. And what I hope we would see is at that time, we would look back on animal research the same way we now look back on the slide rule. It was something that provided us with scientific, cultural, and social successes. It helped us be better as a society, but it's been surpassed, just like the slide rule has now been surpassed by newer and better technologies. So let's talk about now, what could our roadmap look like to get to this great new world? I don't know for sure all of the steps along that road, but I have a pretty good idea of where we can start and how we can make some real progress. I also know that it's going to take passion, vision, and a whole bunch of effort to make this work. Just because it's doable doesn't mean it's easy, but nothing that's really important ever is easy, is it? Let's start by laying out the first step along this road. And I believe the first thing we need to do is we need to focusing on changing the gold standard in research. Right now, the gold standard in research is using animal models. And we need to move away from animal models and create a gold standard that's organized around models that do not use sentient creatures. How do we do that? Well, I suggest one way we do that is we incentivize scientists to study in that area. As I mentioned earlier, there's a lot going on in this area, but we need more activity. We need to pump resources into this so that we get new scientists actively involved, and we energize scientists who are now working on animal models to switch over. How might we do that? Let's think about NIH for a minute. The NIH has a budget of approximately $40 billion a year. That's billions with a B. If we took just 1% of that, which is $400 million, and earmarked that for non-animal alternatives and non-animal methodologies, that would be a great first step forward. So that's the first thing I would do, incentivize the science so that we can accelerate its development. The second thing I would do is to recognize that we have a system now that's not very transparent. I believe the public has a right to know, and in fact, everything I've seen indicates that the public wants to know a lot more about what's going on in the laboratories and in research settings. So I would make a system change so that we actually built transparency in. Now, I don't want to suggest that everything should be open to the public. There's a lot of confidential information, a lot of trade secrets that still need protection. So I'm not suggesting taking away from the principal investigator the keys to the laboratory door. I just want to build some windows in that door so people can look in. Two important things need to happen to make this system more transparent. The first thing is we need to get a national count of the number of animals that we're using in research. This is essential. Now that might mean, probably will mean, changing the definition of animal so that we would use one rather than two definitions of animals in this field, and that one definition would be much more encompassing than either of the two we have now. The second thing we need to do is we need to make more of the local facility records available so that people who care about how animals are treated in facilities can actually go and see how decisions are made and what decisions are being made. So increasing transparency would be my second recommendation about how to reform laboratory animal law. My third recommendation is that we need to begin a serious national conversation about what animals are owed under the law, and in particular, how animals should be treated and perceived under laboratory animal law. In our current system, animals have certain protections. They are supposed to be protected against pain. They're supposed to not be under distress and stress, assuming that the research protocols allow for that. And all protocols are supposed to be reviewed by IACUCs so that not too many animals are used and that all of these pain, stress, and distress issues are checked by an outside body. But under the current system, animals are still treated as property, and we have to ask ourselves whether that's enough. There's an irony here that's not lost on me, and that irony is that we study non-human animals because many of their biological systems are very, very similar to human systems. At the same time, though, we're not recognizing that these sentient creatures can do also things that we as humans do, like experience emotion. And that does bring up the argument as to whether we really do owe them more than just keeping them as property. That is a serious national conversation we need to have because it will help us end the polarization that we now see in this field. So these are 3 important steps that I think we need to take to walk the road before us. Pursuing these changes is going to take people who have creativity, passion, and vision and aren't afraid of hard work. Thank you for listening to me today. For the Brooks Animal Law Fundamentals, I'm Paul Locke.